confused resident tells somebody that somebody came in during the night and slapped her face. So I would, even when you're confused, you could still know that somebody slapped your face. I mean, I guess it depends on your level of confusion, but I'd also look to see, is there anything? Is there anybody around? I would talk to a few people, but I would probably report it and then later on come out with my determination. Within 2 hours. That, I mean, I can't give you another answer because that's what the feds say.
Said that they don't expect you to have your summary of investigation completed. They don't expect any of that. They said they want to triage cases. They put them in buckets. So if they feel they need to come in on something that was alleged immediately, they will. Otherwise, it will be within around 2 weeks. Others could be months based on what they're getting from you and as the follow-up. So that was kind of their answer. Yes.
So the question is, let's take the example about the confused resident, and we have a lot of documentation that the patient fabricates stories. Then I would think at that point, I would not have reasonable suspicion that that person actually got slapped. Unless there's a mark on their face or somebody else says to me, I heard somebody come in and I heard a noise, or, you know, barring something like that. Okay. More of the same. Okay. So here's another one that I think is going to be a game changer in the new regulations. Okay. So now Section 2803W allows the Department of Health to force the facility, for lack of a better word, to contract with an independent quality monitor that's selected by the Department of Health, who will report directly to the Department of Health to monitor the operator's compliance with a written and mandatory corrective action plan. And we'll go through this, but here's my concern. While we look at this and we think, gee, the state comes in, there's some kind of deficiencies, we'll go through that. They're going to mandate us to get, you know, whomever to monitor this. In the back of my mind, I wonder, what is the Medicaid Fraud Control Unit going to do with this? While it says it's the Department of Health who can mandate, I wonder, in my cynical mind, if the Medicaid Fraud Control Unit will go back to the Department of Health and say, look at what we found, look at what we need, you need to bring in an independent quality monitor. So that's the first thing I thought of when I read this. So let's go through it. Okay, so DOH has authority to do this when there's deficiencies that show, one, a condition or conditions in substantial violation of the standards for health, safety, and resident care that constitute a danger to the residents or other, a pattern or practice of habitual violation of the standard of health, safety, or resident care, any other condition dangerous to resident life, health, or safety. So we got that catch-all in there. And here's a way. So obviously we don't have any kind of staffing levels or staffing requirements that are in the law, but here's a way to get around it. Mandatory corrective action plans must include caps on administrative and general costs that are unrelated to providing direct patient care or care coordination. So I find you have a problem, I'm putting in my monitor, I'm making sure that you don't spend more than X percent, 10%, 5%, whatever it is, on administration and general costs that aren't direct patient care. So I think that this is a way that they're going to get around the whole staffing level issue, and I think we need to kind of be very aware of this, because I think that this one is going to be a big deal for us. And I think for anybody that's dealing a lot with the Medicaid Fraud Control Unit, I hate this provision because I think that this is going to cause us consternation. Questions on this? Can I define general costs? No. Anything? Right. And you could be 100% right. The question was, what goes under general costs? The answer is, I don't know. Obviously, nursing, CNAs, therapies, all of your direct care workers are going to be, under direct costs or patient costs, but I'm not sure what would be under general. And so there was another question here. I forgot it already. You had a question. An example of with the Medicaid fraud? Okay, so here's my concern, and I know that this is not a secret to anyone, but there was a facility out somewhere that part of their settlement with the Medicaid Fraud Control Unit was that they had to bring in an independent quality monitor. This happened before this, okay? And it was not based on anything in the law or anything that they had jurisdiction to do, but they did it, and the facility agreed to it, and they brought somebody in whom reported directly to the Medicaid Fraud Control Unit. So I fear that they're going to use this provision so that when other attorneys perhaps are not as accommodating as the attorneys that this facility had, for whatever reasons they had, I'm not criticizing, that they have this provision in the law now to say, you know what, I think your staffing is no good, I think you do this wrong, that wrong, and the other thing, we're going to settle with you, but I want a quality monitor there for 5 years. And you have to pay for it, because I'm not paying for it. You have to pay for it, but that individual or those quality monitors are going to report directly to me. Did that answer your question? Okay. Okay. Other one, notices. So now we have to give all of our residents prior to admission the admissions agreement, and it should be on our website. Pretty much not that big a deal. This one, this is their other transparency thing, 2803C. They want us to let all of the residents know what our policy is on credentialing physicians. So we're supposed to give it to them before they come in, and the thought is if they want to have their own physician, they should have a way to know how the physician could get in or what the credentialing process is going to be. So if we don't have a credentialing policy, we need to develop a credentialing policy, and then we either have to attach that policy or put some kind of blurb of the policy, something easier, into the documentation that we give residents before they come in. Okay, so these notice requirements, what's today? Oh, so these notice requirements were effective 2 weeks ago or something like that, February 18th. You do the math. Eve, you're up.
Thank you, Lourdes. So the only thing I want to mention also with respect to credentialing is I find that so interesting that the state changed a statute to mandate that you provide information, your policy about credentialing. Because, as many of you may know, the credentialing process is a confidential one. And it's required to be confidential under the credentialing laws. It's the same law that protects QA materials, that protects the confidentiality of credentialing. So I find that new statute to be very interesting, and I'm curious as to what happens and whether anybody challenges it on that basis. Because otherwise, it's a process that should be confidential, and because the whole process is designed to ensure that people speak freely and honestly about whether somebody should be credentialed. I think the Department of Health's concern here in nursing homes is that we want residents to know that they are entitled to have their own physicians, who they may have had in the community, be able to continue to provide services to them while they're a nursing home resident. So this was really designed for that purpose, and just so keep that in mind. So I'm going to talk a little bit about mental hygiene legal services, because this was another change in the law at the same time. This was effective immediately, and mental hygiene legal services role was expanded to be able to represent residents of nursing homes who are admitted directly from a hospital that is licensed by the Office of Mental Health, or from a facility that's licensed by the Office for People with Developmental Disabilities, who have a serious mental illness or intellectual disability and are receiving services related to such illness. So what or whom is Mental Hygiene Legal Services? It is an agency, this is a state agency that is part of the New York State court system that consists primarily of attorneys who provide advocacy services to persons who have mental illness or intellectual disabilities and are residing in facilities licensed either by OMH or OPWDD. So that is their jurisdiction and has been their jurisdiction for many years. And prior to this legislation being enacted in December, MHLS had no legal authority with respect to your residents. Even if they were persons with serious mental illness and came to you from a freestanding psychiatric hospital or psychiatric unit of a general hospital. They had no jurisdiction to represent these individuals, even though while those individuals were in the hospital, they were represented by MHLS. And the history of how this came about is the New York Times did a series of articles about many individuals who were being, instead of warehoused in state hospitals, state mental health hospitals, were now being held in neurobehavioral units in nursing facilities. And they had none of the same rights and none of the same access to having advocacy services by an attorney to help represent them with respect to their admission and care and treatment and discharge. And then MHLS conducted its own investigation and started to follow the people who they were serving in hospitals that were going to nursing homes. They knew where they were. They just came out of the hospital. They knew exactly what nursing home they went to. They went to the nursing homes and said, I want to meet with that patient. I want that patient's medical record. I want to know what care and treatment they're receiving. I want to know what's happening with respect to their discharge plan. And the nursing homes said, you don't have any right to that. That's not your legal authority. You don't have any jurisdiction over that. No, you may not come in and meet with that patient. No, you may not have access to their medical record, not unless the resident signs a written consent and allows you to have access to their medical record. And by the way, you don't get our policies either. So, Mental Hygiene Legal Service sued the nursing homes, and the Court of Appeals agreed and said MHLS is their whole legal authority emanates from a statute. There's a specific statute that talks about what their legal authority is and who they represent, and they only represent individuals who are residents or patients in a facility that is licensed by OMH or licensed by OPWDD. So this went to the legislature, and very often, there was a lot of inaction, but in 2019, finally, there was a law that was passed that now expands their authority to represent these individuals. So what does that mean to you? Well, it's now another state agency that's going to be looking at you and asking for your policies and procedures and asking for the medical records regarding that resident and asking to be involved and saying, we are the resident's attorney. We have a right to participate in care plan meetings because the resident may not want to have this treatment. The resident has a right to refuse treatment. We have a right to represent this individual and advocate for them because they don't want to be here. They want to be discharged. And we want you to be working on a discharge plan and to help that resident get transitioned back to the community. We were here in the fall. We talked about the Olmsted decision, right? The residents, the focus on residents having the right to be in the most integrated patient care setting, and our obligation to try to link residents to open access programs to be able to return to the community. Now you're going to have a group of lawyers who are going to be visiting your facility with respect to these qualified residents to advocate for them. So they can talk about any one of these things: admission, care and treatment, including objection to treatment, discharge planning, quality of care, residents' rights. I don't think MHLS is all that knowledgeable yet about residents' rights, but they will be. They have an arm, they have a special litigation office that just focuses on learning the law and then educating everybody in the agency about what the law says. They will put out their own internal documentation, so they will become educated. And then the last bullet, there's a specific provision. This is already existing within the body of law that governs MHLS's authority, all these things. The last bullet, MHLS is entitled to advocate for residents and have information regarding investigations of resident abuse. So this causes a number of questions that come up in my mind, because I'm thinking about QA materials, I'm thinking about the investigations that we do, what part of our investigation they're going to have access to, and what part of a quality assurance material, which is otherwise protected, should they not have access to. So as we move forward in this arena, and as Lourdes said before, we're in brand new territory here. There's not a lot of information. And the access that MHLS has is very, very broad. The statute says that they must be granted access to the person at any and all times, and they may demand access. This is taken directly from the statute. MHLS may demand access to information, books, and records deemed necessary to carry out their functions, powers, and duties. So we went over the list of their functions, powers, and duties. When they walk into a hospital, they get just about everything they want with respect to the mental health side, right? Not the general, not a medical surgical floor, but on a psychiatric unit, policies, procedures, the medical record concerning the patient. If they want it, they have absolute access to it. They're entitled to participate in meetings, in discharge planning, and they can walk in at any time and be given that kind of access. So now they're going to walk into our facilities and say, well, I represent Mr. Jones, who just came to you from the psychiatric department at NUMC, and I want to see their medical record, I want to see this, I want to see that, and they're going to start demanding and think that you all know you're supposed to give them access. And you will have to give them access. I do think we have a question about QA materials. And so that's where I'm concerned about how we're doing our investigations, what part is QA, and what part is going to just be part of the investigation. So consider that as we move forward. So the next topic I'm going to talk about is emergency preparedness as part of the CMS changes in the regulations. Question, sorry, let's go back, MHLS. They do not have authority to issue a deficiency or anything like that. That is not what they can do. But they can go and make a report to the Department of Health or to any other governmental agency that they think is appropriate. So they can certainly file a complaint and cause that to be taken. And because these are not private attorneys, these are attorneys that are paid for by the state. Their resources are slim, I will say that. They have had to deal with a little less in terms of attrition. They haven't replaced that. But when they get a bee in their bonnet, they will take it all the way to the Court of Appeals, as you've seen that they have.
I think we have another.
Yes.
How do we identify who is covered under this, and and when they show up at our door, is this the real deal, or how do you identify that these people are the ones that have the right to this? Could be any attorney, it could,
Okay, so Mental Hygiene Legal Service will have identification on them. It will probably say New York State courts because they are a division of the courts. And they will always be able to present this. So the question is, how do you identify the person showing up at your door? Is it me walking in saying, I got a business card? Not the same thing. Mental hygiene legal service attorneys will have a state-issued identification. It will probably say New York State courts on it because they are employees of the courts, and they'll be able to show that to you. So that was the question, how can you identify them? And they could, and quite frankly, I think they'll introduce themselves. They should introduce themselves. When they come to your facility, they should introduce themselves to somebody in administration to say, hi, my name is Joel Gorinsky. He happens to be one of the mental hygiene legal service attorneys in Nassau County. My name is Joel Gorinsky. I'm from MHLS. Mr. Jones was just admitted to you from NUMIC, and I happen to be his attorney, and I'd like to, I'm going to meet with him. And I think you'll find that they are responsible in that way. They don't need a subpoena. They simply walk in and say, hi, here I am. Here's my identification. I'd like to have the record, please.
What about the pool of residents? So residents with serious mental illness that have a level 2, that not necessarily coming from a psychiatric setting, wouldn't be under their jurisdiction. Is there a way for
That's
facilities
correct.
to know that?
So in order to be under their jurisdiction, it has to be a resident with serious mental illness who is admitted to you from a facility that is licensed by OMH. So let me give you an example. Patient is at, I'll continue with the patient at NUMIC. The patient was at NUMIC. They were in the psych unit. They went to medicine. They left medicine with a PRI, came to you. Not someone that MHLS represents. That same patient comes to you from the NUMIC psychiatric unit. It's the psychiatric unit that's licensed by OMH. That's the patient that is now represented by MHLS. It should be on the patient review instrument. When you're getting a PRI, it should be reflected, and they should, quite frankly, have a level 2. That's correct. Yes. So the question is, what about patients, residents that you have now that came to you a year ago from a psychiatric unit? Are they covered by this statute? The answer is yes. But take that same patient again. Now there was an intervening. I mean, this is where the law gets really fuzzy. There's now an intervening hospitalization. So again, it's a year ago. A patient came to you originally from NUMIC. Then they went to the hospital for medical care. They got medical care. They came back. Is that a patient covered by MHLS? That's not clear because their current admission was not from the psych unit. But I would say MHLS is going to tell you yes. And the answer to that is, do you really want to fight with them? I mean, part of it is, do you really want to fight?
Maybe they don't want to admit some of these patients. I mean, maybe that's something.
Well, that's part of it. I mean, let's talk about what the problem is. This all comes about because of a very complicated issue with a shortage of housing for mental health services, the closure of state hospital beds for mental health services, a real need for mental health services in the community setting, and really just an absence. And so very often we're seeing people admitted to nursing homes who were legitimately admitted to the nursing home for a clear nursing home purpose. Maybe it was rehab because they fractured a bone. Maybe they have been non-compliant with